All right, good morning. This is the Energy and Carbon Management Commission. It is Monday, the 13th. We have a special business meeting today because we've got a lot of business to do. Let's do the roll call.
Thank you, Mr. Chair. Commissioner Ackerman. Here. Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Ray.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Great. Welcome, everybody. The first item on our agenda is commissioner comments. I have a couple of comments and we'll recognize other commissioners if they have comments. Commissioners, I wanted to note for the record, I'm looking forward into our next coming up agendas, and I note that currently on November 29th, we have the Coyote Trails Form 2s. These are 7 Form 2s associated with an oil and gas location that was approved in November of 2017. A number of the other wells on this location have already been drilled, and the applicant, which I believe is Civitas or one of its companies, is now seeking approval of the Form 2s. Looking ahead to that, I note that we've got a couple of local governments that are seeking to petition in. I think that the applicant is responding to that at this point. I don't believe the hearing officer has made a recommendation on that at this point. Looking at this, that the Form 2A was for a surface location that was approved under the old pre-mission change rules, and we're going to bring that to us for consideration. I believe that under these relatively unique circumstances, the commission cannot and should not make a fully informed decision on this without CDPHE's input pursuant to the current rules. I would like to instruct the director to reach out to the appropriate person. I believe that's Tessa Sorensen at CDPHE to review the APDs. I would like there to be a CDPHE consult on these Form 2s. And I also would like to instruct the director to include the applicant on any such communications. So those are my thoughts moving into something that's pending before us. Does any commissioner have any grave concerns with that direction? Commissioner Messner?
Thank you, Mr. Chair. No, I appreciate you bringing it up, and I think that makes a lot of sense to me. So would agree with your consideration there.
All right. Seeing no one with any concerns, the director is so directed. So thank you for that. Going a little bit out of protocol, Mr. Thomas, hearings manager, would like to recognize you, and perhaps you can introduce some new folks to us on our team.
Thank you, Mr. Chair. Just briefly, I'd like to introduce Janet Jacobs to the commission and everyone listening in. She's a new hearing officer that joined us last week. You can see her on camera. She joined us from Missouri, where she served as a hearing officer and an ALJ at other agencies, and also previously worked at an oil and gas firm. And we are beyond excited to have her here, and hope to have her present some stuff to you in short order.
Oh, excellent. Janet, do you want to introduce yourself? Good to see you.
Good morning. I just wanted to say thank you. It's an exciting time to join the commission, and I appreciate the opportunity. So it's nice to meet all of you, and I hope to meet you in person. Thanks.
Yeah, likewise. We look forward to seeing you in person. Welcome to the ECMC. It is an exciting time for all of us. It's great to hear of your relevant background and experience. We need all the help we can get, so we look forward to working with you. I look forward to your presenting to us soon on matters. Excellent. Okay, back to our regularly scheduled television program of commissioner comments. Any other commissioners with comments? Commissioner Messner?
Thank you, Mr. Chair. Just a couple of comments. One, I wanted to let the commissioners know that we had our 3rd Colorado Produced Water Consortium meeting last Thursday, where the group completed the first steps in our strategic planning to around the Colorado Produced Water Consortium. I think it was a really good meeting, and now we have 5 strategic priorities with associated strategic results that came out of a couple of days of strategic planning. I think I was very impressed with the work that the consortium members did. It's a big consortium, but we were able to come to consensus on the items that were developed, and looking forward to continuing the work of the consortium early December, where we have our next meeting. We've got a lot of work ahead of us over the next year in order to accomplish the deliverables that are associated with House Bill 23-1242, as well as other work that the consortium would like to accomplish. So shout out to Hope, who's the new director of the Colorado Produced Water Consortium, for helping us work through the strategic planning process. So I think it was good. Happy to answer any questions about that. And then second item is I would like to request an executive session this morning to get legal advice specifically on the Opal Coal Bank OGDP, as well as the BL Vintage OGDP.
All right, thanks for the good work on the consortium. When one commissioner desires an executive session, we generally grant said executive session. So we'll go into that here in just a bit. Any further commissioner comments? All right, Hearings Manager Thomas, I do note that we had one person that signed up for public comment, a certain Greg Berger. Do we have Mr. Berger in the, or Craig Berger, sorry. I see a Craig in the participant list. Perhaps that's the relevant Mr. Berger who signed up. Can we elevate Craig to the panel? Craig, I see you're with us in the panel. Do you want to unmute yourself?
Yes, I believe have I managed to unmute myself?
Yep, we can see you and we can hear you. Are you the Craig Berger that signed up for public comment?
I am. Thank you, sir.
Oh, great. Good to see you.
Okay. I'll try to keep this brief. I would like to make comment regarding your geothermal rulemaking that you proposed. And I'd like to say, please do not pass the currently proposed straw dog geothermal rules. I suggest you kind of go back to the drawing board. The currently proposed rules will impose the same burdens on the nascent geothermal industry that are imposed on the fossil fuel industry. Yeah, and the rules, the red tape, and onerous permitting process currently in place on the fossil fuel industry are there for a reason. Drilling and production of oil and gas did result in significant impacts to public health, safety, welfare, the environment, and wildlife. As a result, strict regulation and a very difficult permitting process was imposed. Geothermal energy production has not and will not impact public safety, health, welfare, and the environment like fossil fuel extraction has. Thus, I think the development of this resource should be fostered, and undue regulatory burdens should not be placed on it. So I suggest allowing staff administrative approval of all deep geothermal proposals with a minimum or no red tape. Certainly requiring a hearing is an undue burden. So I'd like to ask you to not drive this potential industry into neighboring states by creating a permitting process that is expensive, time consuming, and requires lawyers to navigate. So please remove the red tape, regulatory hoops and traps, and just approve geothermal projects as soon as possible. So thank you for listening to me today. Respectfully, I was your previous Western Region Engineering Supervisor, Craig Berger. Thank you, gentlemen, ladies and gentlemen.
Craig, thanks for being with us. Yeah, I remember you being with us. Appreciated working with you. I appreciate the comments this morning. What I'll make sure we do is we move those comments into the geothermal portfolio so that we've got those in the relevant space. Commissioner Ackerman is running lead on that, and I'm sure he'll make note of that, and we will continue forward with those comments in mind. So thank you very much.
Thank you. Thank you for your time.
All right. At this time, we would move to consent agenda. Does anyone have questions with regard to consent? Seeing none, do we have a motion to approve consent?
So moved. Second.
Motion from Commissioner Cross, second from Commissioner Ackerman to approve consent. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. All right, at this time, I would recognize AAG Davenport, I believe, or AAG Mercer, one of our two esteemed lawyers. We're going to move into executive session. Do you want to read the script?
Yes, thank you, I will. So pursuant to the open meetings law, the commission is entitled to enter into executive session at this regular meeting to receive legal advice pursuant to Colorado Revised Statutes, section 246402-3A2. The topics of the executive session were identified by Commissioner Messner in his comments, and that is advice on the Bayswater Opal Coal Bank OGDP and the Providence Operating Company BL Vintage OGDP. So with that, Chairman Robbins, I would invite you to encourage a motion to enter into executive session for those purposes.
I will encourage a motion to enter into executive session.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? All right, folks, if you are been familiar with the work we do here at the ECMC, we are going to go into an executive session, which is allowable under Colorado law as articulated by AAG Mercer. What we're going to do is we're going to leave this Zoom meeting. We've got a separate Zoom meeting set up, and we'll go into that meeting for executive session. No decisions will be made. We will just receive legal advice. Once we're done, we'll return to this meeting. I can only identify a guess as to how long we'll be. Maybe 30, 45 minutes thereabouts. So for the rest of you, just if you want to hang in the meeting here, please do so. And we will be back. I will have the meeting posted here with a tentative return time. Once we know what that return time is, we will make it final. And we will see you back here in just a bit. Thanks. All right, welcome back, commissioners, and welcome back to our stakeholders that are listening in. This is the Energy and Carbon Management Commission. It is Monday, November 13th. It's 10:30. We just participated in an executive session. I would recognize one of our attorney generals for next steps.
Thank you, Mr. Chair. I will just read us back into session. I would note that we are returning from executive session. During executive session, the commission received legal advice on the Providence Operating Company and Bayswater OGDPs. No decisions were made and no votes were taken. And with that, I'd invite you to encourage a motion to exit executive session.
So encouraged.
So moved.
Second. Motion and a second to exit executive session. All those in favor signify by saying aye.
Aye.
Any opposed? All right, we are out of executive session. We're back in our general agenda. Let's proceed to our docket. The first matter is docket 221100289. This is an oil and gas development plan. The applicant is Wave Tech Helium, and the attorney is Ms. Waslinki. Good morning.
Good morning. Thank you. I believe we are still admitting our panel.
Yeah, and I see hearings manager Thomas, as well as oil and gas location Ogla Halsey. Did you guys want to bring something to bear?
Yes, Ms. Halsey has a brief statement before we begin.
Yes. Thank you, Mr. Thomas. Good morning, commissioners and public. The CPW consultation summary mentioned in the director's recommendation was not attached at the time of the publishing of the director's recommendation on October 27, 2023. Once this was discovered, it was attached on November 6, 2023. No other changes were made to the web form materials in the interim, and the director's recommendation for this oil and gas development plan remains the same. So apologies for any confusions this may have caused.
Okay, thank you very much. Ms. Waslinki, I think next step is to bring your witnesses to the table and then we'll have them sworn in.
Correct. I think we have if everyone could please turn their cameras on. Scott Davies, I don't believe we have him yet. He's the last presenter to be, or witness to be admitted. We have everyone else.
Can get started with the folks who we have, and hopefully Mr. Davies will appear before we're done.
Great.
To members of the panel, I'll go one by one. You're mostly familiar with this drill. I'll ask you to raise your right hand, state your name, and that you swear to tell the truth. So I will start with Mr. Gendelman.
My name is Igor Gendelman. I swear to tell the truth.
Thank you. The other Mr. Gendelman? You're on mute.
You're on mute.
We can come back to
I'm sorry, I had my mute on. I'm sorry. My name is Edward Gendelman. I swear to tell the truth.
Thank you. Mr. Eby?
My name is David Eby. I swear to tell the truth.
Thank you. Ms. Gross?
My name is Andrea Gross, and I swear to tell the truth.
Thank you. Ms. Vogel?
My name is Patty Vogel, and I swear to tell the truth.
Thank you. Mr. Falk?
My name is Steve Falk, and I swear to tell the truth.
Thank you. Mr. Bowen?
My name is David Bowen, and I swear to tell the truth.
Thank you. Mr. Joby?
My name is Patrick Job, and I swear to tell the truth.
Thank you. And Mr. Davies? Mr. Davies, if we could have you turn your camera on and raise your right hand, state your name that you swear to tell.
My name is Scott Daves, and I swear to tell the truth.
Thank you. I believe that is everybody, unless I missed someone.
It is. Thank you. All right, Chair, we can get started if that works.
Yep,
okay,
that works.
We will start our screen share, and I will get going. And Andrea, if you could put it in presentation mode.
All right. Is that,
there we go.
Is everybody seeing that? Okay.
Yes.
Yes.
Fantastic.
All right.
Thank you.
Thank you. Well, good morning again, commissioners. My name is Kelsey Wazelinski with Jost Energy Law. And with Jamie Jost, we represent WaveTech Helium in the Burlington ROSA Helium OGDP before you today in docket 2211-00289. We would like to thank Karen Voltura for her guidance and efforts on behalf of CPW, Cheyenne County for their support of the OGDP, and also ECMC staff and the director for their efforts on this OGDP. Next slide. I'll take just a few minutes to summarize the Burlington ROSA Helium OGDP and requested relief before I turn it over to WaveTech. This OGDP requests that the Commission establish an approximate 344.32 acre drilling and spacing unit for the development of the ROSA 3110 re-entry in the Morrow V5 formation. The OGDP also requests approval of an approximate 988.44 acre oil and gas development plan for the development of one re-entered vertical well and two new vertical wells to target helium gas in the Morrow V3 and V5 sandstone formations. The three requested Form 2As are for the number 1 WaveTech FPI Burlington Farms 43-2 pad, the ROSA 3110 number 1 pad, and the number 1 WaveTech FPI Burlington Farms 3211 pad, as shown on this map. WaveTech will utilize two 320-acre drilling and spacing units established by Order 477-3 for the Burlington Farms 43-2 pad and the Burlington Farms 3211 pad for the targeted Morrow V3 sandstone. The re-entered ROSA 3110 well is targeting the Morrow V5 sandstone, which was not spaced by Order 477-3, and therefore WaveTech is requesting this new drilling and spacing unit. All gas produced from the Morrow Reservoir will produce directly to the existing Ladder Creek pipeline system. WaveTech does not expect to produce oil as part of this development. The three proposed locations are located within Cheyenne County. Cheyenne County does not regulate the siting of oil and gas locations. However, WaveTech has been in close communication and consultation with Cheyenne County throughout the OGDP process and has the county's full support. WaveTech also had extensive consultation with CPW and U.S. Fish and Wildlife as part of this OGDP. The locations are within the Lesser Prairie Chicken Estimated Occupied Range, or EOR, which encompasses almost all of Cheyenne County. WaveTech will discuss the status of a comprehensive wildlife mitigation plan in the presentation today. WaveTech's alternative location analysis and protective BMPs will also be covered in the presentation. And finally, WaveTech has complied with all notice requirements for the OGDP. No formal petitions were filed, and no public comments were received on the Form 2As. And with that, I will turn it over to Igor Gendelman, the Vice President of WaveTech, to continue the presentation.
Thank you, Kelsey. Good morning, commissioners. My name is Igor Gendelman, and I'm the Vice President of WaveTech Helium. I appreciate the opportunity to present the Burlington Rosa Helium OGDP. Next slide, please. This is WaveTech's second hearing in front of the commission, but I will still emphasize a couple main points of introduction. Helium is an essential element for multiple essential industries and applications, and it's in short supply right now. Helium production potential in Southeast Colorado is still very large, and it can be utilized with a very small environmental footprint. WaveTech staff has a lot of experience in this area, and we are leveraging it in our efforts to deliver more very much needed helium. I would also like to note that Steve Falk, who assisted with our wildlife mitigation plan, is at the hearing and ready to answer questions. Next slide, please. This is an overview of Burlington Farms 43-2 pad location. It's in Cheyenne County, which doesn't regulate the siting of oil and gas locations. However, we still consulted with the county and are in contact with its representatives. We plan to drill one conventional vertical well at this location, which will produce helium containing natural gas and water. All the gas production will go to an already existing Ladder Creek plant through an already existing pipeline system. This location is fee surface and fee minerals, with total drill and pad disturbance of about 3.5 acres. It's within the Lesser Prairie Chicken Estimated Occupied Range, and we engaged in Rule 309 consultation with CPW and conducted ALA. This location is more than 2,000 feet away from all residences, buildings, and schools, and the closest town is Arapahoe, which is 13 miles away. Next slide, please. This is overview of Rosa 31-10 #1 pad location. We plan to re-enter here one conventional vertical well, which will produce helium containing natural gas and water. All the gas will go to an already existing Ladder Creek plant through an already existing pipeline. This location is fee surface and fee minerals, with total drill and pad disturbance of about 3.5 acres. It's within the Lesser Prairie Chicken Estimated Occupied Range, and we engaged in Rule 309 consultation with CPW and conducted ALA. This location is more than 2,000 feet away from all residences, buildings, and school, and again, the closest town is Arapahoe, which is about 13 miles away. Next slide, please. And one more location, which is Burlington Farms 3211. Again, we plan to drill one conventional vertical well at this location, which will produce helium containing natural gas and water. All the gas production will go to an already existing Ladder Creek plant through an already existing pipeline system. This location is fee surface and fee minerals, with total drilling pad disturbance of about 3.5 acres. It's within the Lesser Prairie Chicken Estimated Occupied Range, and we engaged in Rule 309 consultation with CPW and conducted alternative location assessment. This location is more than 2,000 feet away from all residences, buildings, and schools. Closest town, Arapahoe, is 13 miles away. Next slide, please. Targets for all three wells are Moro fluvial channel sandstones. Rosa wells target is V5 channel, and Burlington wells target V3 channels, which is younger and shallower. Next slide, please. This is the permitting timeline. WaveTech will continue to work with ECMC staff on process improvements for improved completeness timing. Next slide, please. This shows phases of operation. Pad construction will take about 4 days per location. We will drill 2 new wells and re-enter an old one. This will take about 14 days per well. Basic production equipment will be installed if the wells are productive. All the gas will go into an already existing pipeline. Next slide, please. This shows the estimated occupied range for the lesser prairie chicken. This EOR triggers Rule 309 CPW consultation. Next slide, please. All the locations are approximately 3 miles from the closest 1.5 mile lake buffer. They are not within a focal area or connectivity area. These are farmlands, so no grassland habitat will be disturbed. We consulted with CPW with U.S. Fish and Wildlife technical assistance. Next slide, please. As you can see, there are a lot of turbines in this area, wind turbines. U.S. Fish and Wildlife suggests the lesser prairie chickens may avoid otherwise suitable habitat within 1,800 meters of a turbine. And our locations will have multiple turbines closer than that. Next slide, please. Following the directive from the Commission at our first hearing, WaveTech engaged an expert biologist to prepare a comprehensive wildlife mitigation plan to cover our first 5 OGDPs in high priority habitat, to be amended as new OGDPs are filed. WaveTech provided a draft of this plan to CPW, received comments from CPW, and an updated plan has been submitted to CPW. Next slide, please. WaveTech has provided alternative location analysis for this OGDP. All the alternative locations trigger the same criteria as the proposed locations. There is no alternative locations that can reach the proposed mineral development that is not located within the lesser prairie chicken estimated occupied range. CPW and ECMC support the proposed locations. Next slide, please. Best management practices matching all the ones for our first OGDP will be used for these locations as well. And now I'll pass the presentation on back to Kelsey.
Thank you, Igor. Next slide, please. As I mentioned in my brief introduction, WaveTech will utilize Order 477-3 to drill and develop the Burlington Farms 43-2 and the Burlington Farms 3211 locations in the Morrow V3 sandstone. WaveTech has committed to submitting exception location requests pursuant to Rule 401C to allow these 2 vertical wells to be located less than 1,000 feet from the boundaries of the drilling units. WaveTech does propose a new approximate 344.32 acre drilling and spacing unit for the north half of Section 10 to develop the ROSA 3110 number 1 location in the Morrow V5 sandstone formation. WaveTech submitted land, regulatory, geology, and engineering testimony in support of the new ROSA 3110 unit. Next slide. To summarize the Burlington ROSA helium OGDP and WaveTech's request for approval, we note the following OGDP highlights. Cheyenne County was consulted and does not regulate the siting of oil and gas wells. WaveTech had extensive consultation with CPW, including coordination with U.S. Fish and Wildlife, and has been actively working on a comprehensive wildlife mitigation plan with CPW for this OGDP and future OGDPs. And CPW supports the siting of the 3 proposed locations. The director recommends approval of the OGDP. And finally, the siting and BMPs provide protection of public health, safety, welfare, the environment, and wildlife resources by avoiding, minimizing, and mitigating adverse impacts. Next slide. This slide shows the relief requested for the Burlington ROSA helium OGDP. We respectfully request approval of the requested drilling and spacing unit OGDP and associated Form 2As. And this does conclude our presentation. So I'll have the WaveTech team please turn your cameras on, and we are now open for questions.
Great. Thank you for the presentation. We appreciate it. Commissioners, at this time, the panel is open for questions. Commissioner Ackerman?
Thank you, Mr. Chair. And maybe they can kill that presentation for us so we can maximize the screen. Thank you so much. Appreciate that. And appreciate your extensive coordination with CPW and Fish and Wildlife Service. Especially appreciate Mr. Falk's participation in that as well. Just a couple of questions. The first one, you mentioned that CPW reviewed the wildlife mitigation plan and submitted comments, and then it was submitted back to CPW. Is the wildlife plan that we received the final plan that reflects their comments, or kind of where are you at in that process? That was a little unclear to me.
Thank you, Commissioner. There have been some updates to this, even since we first submitted this presentation. So maybe I'll have Mr. Stephen Falk answer that question on where we stand with the comprehensive wildlife mitigation plan.
Thank you for the question, Commissioner. Thank you, Kelsey. We've worked, the version that you received has been reviewed subsequently by CPW and ourselves. And we received some very useful and helpful comments from Colorado Parks and Wildlife. And so we have one more iteration to respond to those comments and then to submit what we believe will be the final for version 1. And just to clarify, we're using the version to accommodate new OGDPs. So if in the future, when a new OGDP is presented to the commission, the version of this plan would change to reflect that and would be updated accordingly.
Thanks, Mr. Falk. That's helpful. Were there significant modifications, anything that was substantive, or was it just tweaks?
I would characterize it as tweaks. The comments came from Karen Votura, and they're very useful and helpful. I would save for her to describe if they were tweaks or not. I don't describe them as significant, if that's fair.
Can you, I'm sorry to keep hammering on this, but can you give us an example of maybe one of those comments off the top of your head? I don't know if you're able to do that, but
I can. I have an example in front of me where in one case we've added a section regarding an impact analysis that ECMC staff would have seen in previous versions of OGDP specific mitigation plans. So we've added impact analysis to this comprehensive plan, and in it were suggestions to mention more specifically what we've discussed with Parks and Wildlife. Examples would be discussions on noise, traffic, light, and impacts on lesser prairie chicken. And I think that's an example of one, and we will address that comment.
Thank you, Mr. Falk. That's helpful. I appreciate your time and your attention to this plan and to this application. I do have one more question, which is likely not directed to Mr. Falk. And as I understand it, it looks like you'll have on each pad here, from what I can tell, there'll be, of course, a jack, but also an oil tank on each pad, a produced water tank on each pad, a separator on each pad, and a meter on each pad. Did you consider consolidating those and creating, pad-to-pad flow lines? And is that something that was considered or could be considered and is possible?
I'll get this. Actually, oil tanks will not be needed because there'll be no oil here, just a little bit of water. And consolidation would produce more disturbance, and just the separators are very small. So it's if we were to connect them with the pipeline, it will create more disturbance.
Thank you, Mr. Gendelman. So if I heard you correctly, each pad will have a pump jack, a produced water tank, a separator, and a meter, but there will be no oil tanks.
Correct.
Thank you.
And pump jacks will come later when water appears.
Sure. Thanks so much. Mr. Chair, that's it for me. Thanks.
Thank you, Commissioner. Other commissioners with questions for the panel? Commissioner Messner?
Thank you, Mr. Chair. Just to follow up on Commissioner Ackerman's question, because I think I'm maybe a little confused now, but will you adopt the final wildlife mitigation plan as best management practices for this OGDP? And if so, does there need to be a condition of approval that would acknowledge that, or is that already been acknowledged in the BMPs?
Ms. Weslinski?
Yeah, thank you, Commissioner Messner. Yes, WaveTech commits to the BMPs outlined in the final comprehensive wildlife mitigation plan. Because that isn't final yet, I believe a condition of approval that those BMPs, should they differ from what's in the current wildlife mitigation plans on the Form 2As, that WaveTech would agree to those once the comprehensive plan is finalized.
Okay, thank you.
Thank you for that. Other questions for the panel? Okay, I'm not seeing further questions. Does any commissioner desire to enter into deliberations and/or make a motion? Commissioner Ackerman?
Thanks, Mr. Chair. I do want to note for the public that lesser prairie chicken is and will be a concern in this area of the state well into the future. We're very well aware of that. The commission has been out to see lesser prairie chickens south of this area and is quite educated on lesser prairie chickens and the impacts of development on lesser prairie chickens. As was noted, almost this entire county is in estimated lesser prairie chicken range, and wanted to reiterate that we appreciate WaveTech and particularly Mr. Falk's extensive coordination with CPW and with the Fish and Wildlife Service. As a reminder, lesser prairie chicken is part of the northern distinct population segment, which is listed under the Endangered Species Act as threatened. I wanted to say that I also appreciate the re-entering approach and trying to minimize disturbance where you can out there. And I do agree with the assessment, as we've discussed in the past, that these, due to the wind turbines, these are areas, although they're within estimated occupied range, that lesser prairie chicken likely already avoids. And so I am in favor of this application and happy to make a motion unless there's further deliberation, Mr. Chair.
Any further deliberation? I think you're allowed to make a motion, Commissioner Ackerman.
Thanks, Mr. Chair, and I appreciate Commissioner Messner's clarification for us. I make a motion that we approve this application with a condition of approval that the final comprehensive wildlife mitigation plan, once it's completed, will apply to the extent that any provisions are different from the materials that we've had in the application materials thus far.
Second.
Motion and a second. Ms. Weslinski, is the capturing of the condition of approval acceptable?
It is. Thank you.
Further deliberation on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Thank you, Ms. Weslinski. Appreciate your time, and thank you to the panel as well as staff for their excellent review of this proposal. Why don't we take 5 minutes and return at 11:04, and at that time I would hope to have the next docket panel ready to go, including counsel for City of Brighton, Mr. Sura. 11:04. All right, this is the Energy and Carbon Management Commission. We are still on November 13th. It is 11:04. We are continuing with our dockets this morning. Next up is docket 2204-00084, an oil and gas development plan. The applicant is Providence Operating LLC. I believe that the order of play here is first that we would hear from the City of Brighton via Council Matt Sura. Mr. Sura wants to visualize himself. We would look forward to hearing from him. Going once, going twice. Mr. Sura, I see you're with us. Do you want to, can you visualize? Commissioners, can you hear me? I'm not seeming to generate any positive response here.
Chair, I can hear you.
Yeah. Well, maybe Mr. Sura is not able to participate just yet. Maybe we could bring the attorney, Mr. Chicken, as well as his witnesses. If they want to open up, we can swear them in and start to get rid of some procedural matters. Yep. Good job, witnesses. Keep visualizing yourselves. All right, well, we've got the witnesses up. Mr. Sura, why don't you hold off just a sec? Let me get the witnesses sworn in since I've got them up. AG Mercer.
Thank you, Mr. Chair, and hello to the panelists. I'll just go one by one as you appear on my screen and ask you to raise your right hand, state your name, and say that you swear to tell the truth. I'll start with Mr. Link.
Yes, my name is Michael Link, and I swear to tell the truth.
Thank you. Ms. Gross?
My name is Andrea Gross, and I swear to tell the truth.
Thank you. Ms. Grimes?
My name is Megan Grimes, and I swear to tell the truth.
Thank you. Mr. Goff?
My name is Max Goff, and I swear to tell the truth.
Thank you. Mr. Smith?
My name is Mark Smith, and I swear to tell the truth.
Thank you. Ms. Bowies? Apologies if I mispronounced your name.
My name's Allison Boyce, and I swear to tell the truth.
Thank you. Mr. Larson?
My name's Scott Larson. I promise to tell the truth.
Thank you. Mr. Frank?
My name's Jason Frank, and I swear to tell the truth.
Thank you. Mr. Is it Witzel?
Frederick Witzel, I swear to tell the truth.
Thank you. I believe those are all of the witnesses, unless I have missed somebody, Mr. Chicken.
Did we capture everybody, Mr. Chicken?
That's everybody. Thank you very much, Ms. Mercer.
Thank you.
All right, Mr. Sura, you are recognized on behalf of the City of Brighton.
Thank you so much. I've got a brief presentation that I'd like to give.
You can share your screen.
Yes, I'll do that now. Can you see that?
Yes.
Yes.
Wonderful, thank you. So my name is Matt Sura on behalf of the City of Brighton. I just wanted to give you a brief overview of the city's position on this and ask you for 3 conditions of approval to be added to this location if it's approved. Just to give you a brief introduction of the City of Brighton, it's kind of a neighbor to the north for the City of Denver. Beautiful town that has about 40,000 in population. It is all about the new energy economy. In fact, Vestas has its buildings right here where it works on wind turbine blades. I've shown you this before, but I've been working with Brighton for 10 years now. And when I first started with Brighton, there was no oil and gas development within the city limits, or even really much under the city limits. Within 5 years, things got significantly different, where a lot of oil and gas development was occurring all throughout this area, as you well know. and including under and even within the city of Brighton. Most of the locations were outside of the city of Brighton, drilling down and then horizontally underneath the city. So didn't have to deal with many locations at all within the city limits. And here it is now. And we've got this location here that we're discussing today. And when we first started, and this is background, of course, but when we first started, it was 2017, talking about this location. And at the time in 2017, preemption was a very real issue. City of Longmont case was recently decided. Essentially, municipal regulations could not be in operational conflict with COGC regulations, meaning that it could not materially impede or destroy the state interest. And that really handcuffed local governments in addressing issues within their municipality, within their boundary, that were industrial issues, oil and gas issues. And so what the city of Brighton did, like a lot of other locations, including Broomfield, Erie, Boulder County, La Plata County, and others, was create two paths in their regulations. One was a conditional use permit, which only required them to do the minimal required by state law. And then there was an MOU proposal, which was much more, I guess, a negotiated settlement as to what, in addition to state regulations, they'd be willing to do. And again, a lot of it was just timing. So we had to give carrots to local governments to be able to make sure that, or to operators to make sure that they were. Let me just turn this off. We had to give carrots to and incentives for operators to want to get an MOU, and one of those was a streamlined path towards approval. Again, these are the two locations within the city that we're going to be talking about. This is the one on the right, is the Providence oil and gas location. Of course, Senate Bill 181 changed all that and gave local governments the ability to negotiate. And you'll note that there's a commissioner here who was involved in that and was behind the man in the chair, as it were. So when we first heard from Providence that they wanted to expand what is now before you, the BL vintage pad, obviously there were concerns about expanding in an area that was within the city limits, but we thought that there may be some ways to improve on the memorandum of understanding that we were able to negotiate in 2018. Ultimately, we signed it in the beginning of 2019, and the only reason we were able to sign it at that time was because, well, Senate Bill 181 passed, and then suddenly everything we'd been asking for over a year suddenly got approved almost overnight. So improvements from the 2019 MOU is that all wells will be drilled with electric drill rigs. Important improvement there. Hydraulic fracturing is going to be done at least with Tier 4 engines. Really, there's not technology available right now to be able to do that electrically, but if they could, they're required to use that. Pipelines used to transport oil and gas, limiting truck trips, permanent production equipment such as compressors all have to be electric line power. Operators should use non-confidential baseline water source sampling to anybody that wants it within a half mile of the location. Operator uses pipelines for the transport of produced water from oil and gas facilities if a reasonable market rate contract can be negotiated. I can talk about that more if there are questions, but there is a line in the area, and we are forcing those two entities to negotiate with one another. We believe a deal will ultimately allow for produced water to be taken by pipeline from the location. Artificial lift can't be used through pump jacks. We want to make sure that the Brighton Lakes pad is held to the lower standard of a single well pad, not the cumulative effects standard. I'm going to get into that a little bit more. And then ultimately they have to, operator has to respond to all complaints within 24 hours. And the operator is going to perform baseline air quality monitoring, both before they start the drilling and then all throughout that pre-production period, and then 3 years beyond, which is, again, greater than state law requires. Moving to conditions of approval, and these are the issues that I wanted to talk to you about today. The first is that all drilling rigs capable of drilling to the maximum measured depth need to be utilizing electric line power. This is an issue that has been and will continue to be, I'm sure, part of the discussions with CDPHE in working through, best management practices. And to be honest, this wasn't something that CDPHE was able to negotiate. Fortunately, with the leverage that the local government has and requiring this as a requirement, making this a requirement, they were able to make it work. And I think that makes for a much better proposal, ultimately saving them money as well. But that should be something that is a condition of approval. One of the reasons why the city of Brighton wants ECMC to have these as conditions of approval is that it is a small local government. It doesn't have staff that can be providing this kind of oversight. It doesn't have staff that can be doing inspections. Really depends on ECMC staff to do that, and would prefer to have ECMC, take that role on to ensure that this condition is followed. The next is the same sort of condition about using a tier 4 hydraulic fracturing engines to minimize emissions. And finally, the expanded Brighton Lakes pad will be held to ECMC rule 423, the 423-1 standard. And this is just the common standard for any oil and gas facility. It needs to be held to, in this case, a rural or a rural standard, a residential standard of 50 at night and 55 decibels during the day. We don't want to see the fact that there are 2 pads co-located to trigger a cumulative noise limit, which is something that had been indicated by one of your staff that they saw this as an area that already had existing noise, and therefore we get this cumulative effects standard, which would bump up those standards to 55 and 60 decibels. And that doesn't make sense. So the way that this came to our attention is that in part of their proposal, they did, as they're required, a baseline noise standard sample, and found that they were already out of compliance in this area. And if you go out there, there's really nothing but these 2 locations. And the reason that they're out of compliance is frankly because they had not electrified those 2 locations, and they were running generators all the time, and the combined noise was well above the noise threshold. Again, staff had indicated that they didn't think that either one was contributing and was over the threshold, but combined they were. And the city of Brighton said that's not okay. We're seeing this as one location, one noise source, and you 2 operators need to figure out how to get it within the residential standards. So with that, I'm open to questions if you have them.
Questions, commissioners? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Sir, for being here today and representing the thoughts of Brighton. So could you clarify for me that one of the conditions of approval is an electric drill rig, but then also electrification of the pad? I hear what you're saying. I think what I hear you saying, the cumulative noise impact being held to the residential level, But that would be after construction when the pads are in place, and then was the city also requesting electrification of the pad itself?
Yeah, so let me take those one at a time. So the first is absolutely right. We're looking at electrification for pre-production and production. So the pre-production aspect of it is really just the drilling rig, because that's what can be done with readily available technology today, and the amount of electricity that's out there, frankly. When you get into hydraulic fracturing and completion, there's just too many engines, too much of a demand right now, and we don't have readily available technologies to be able to do that electrically. And so kind of second best is a tier 4 diesel engine, which would reduce nitrogen oxides in the area considerably than if they were using a tier 2 as an example. So then moving to the production phase right now, that is not using line power. As I mentioned, that creates nitrogen oxides, it creates additional noise. All of that is going to go away because the entire pad and all of that production equipment is going to be electric. The issue of noise is really a separate issue. We have in our regulations 2 noise standards. One's a kind of a cumulative effects noise standard, which is if there is existing noise present, then that operator, and they're already out of attainment, that operator is not held to that same standard. They're held to a much higher noise limit. And that just doesn't make sense in this case, because the noise that is there is already oil and gas noise from these 2 pads. We believe that working together, these 2 operators are going to be able to bring their combined pads into the lower threshold of residential, which is 50 decibels during night and 55 decibels during the day.
Thank you. That's helpful. Something I've been struggling with as part of this application is what's happening with the current pad. I think PDC is the owner. They still have the opportunity to drill additional wells on the adjacent pad from this location. And I'm wondering what Brighton has done to work with this operator under this application, as well as the existing pad location, that operator, to try to work through some of these issues of timing and what might happen on the existing pad, what's going to happen at this proposed location, how all those pieces are going to fit together.
Commissioner McGowan, that's a great question. And as we were working on this process with Providence, we were approached by PDC, and they held up their hands and said, we've already got the approvals that we need from you back in 2018, 2019 for this location, but we want to make some improvements. We want to change the configuration, and we're going to get to starting to drill those wells. And so we said we're going to need a new memorandum of understanding. And part of the memorandum of understanding, both with Providence and with PDC, is that they have to work together on those timing issues, so we don't have 2 rigs at once, that there's going to be transportation issues. There's likely going to have to be improvements to that road, because it's not going to be able to deal with all that industrial traffic all at once. We're looking at requirements for landscaping to make it sort of one location and kind of obscure it all, and noise. So all of those issues are addressed in the MOU that is before you, that I know was attached to the materials that I sent, at least, and go into all of those kind of issues that need to be negotiated with PDC. One of the most important ones, PDC has a subsidiary, Pioneer, that does the water pipeline in the area. And we had just been talking to Providence about really a concern about those water trucks, and wouldn't it be great to get that water takeaway through pipeline. With one location, Providence really didn't have the capacity to be able to do it on its own. PDC, however, has all sorts of oil and gas throughout that area, and had already just approached Brighton for through their subsidiary Pioneer, for an easement and permission to have a pipeline to go to the adjacent prairie pad that is immediately to the east of this Providence pad. And we said, that's great. As a condition of approval, we're going to have you take away the water from Providence's pad. And at first, PDC said, no, it's going to be only for our use, only for PDC. And we're like, look, this is going to be better for everybody to get those trucks off the road. And it was only after they started that they got purchased by Chevron that they came back to us and said, yes, we are interested in working with you. And we can't force a negotiation, we can't force an outcome. But I think both parties, all three parties, are really interested in finding a way for this water pipeline that still hasn't been approved by Brighton to ultimately carry not just water from the prairie pad, but also adjacent pads in the area.
Nice. So from reading the description and kind of some other things that are happening in the area, are you all also working with PDC on timing to make sure that their development gets done before, I think you have a commercial development and residential on the books for future development, and Brighton wants this done first?
That's exactly right, Commissioner McGowan. This is we can't have development that would occur, residential development in particular, that would occur before that oil and gas development occurs, either on the prairie pad or the BL vintage. So we're looking to have this done within the next 2 to 3 years, have all of those wells done, interim reclamation occur, and all landscaping, and make sure that it's all fenced off and it's completed at that point. The residential development is going to happen, but it's probably not, it's probably more than 5 years out at this point. That would be immediately adjacent to it, at least.
And last question, at least I think it will be. Has Brighton talked with the RBs that are the closest? And I think, a lot of discussions that we have as commission is activity that like one and done, get in and get out. And in this case, you have a conflict with, if you have two operators doing something at the same time, now you've got noise that's possibly going to be burdensome for the neighbors. And so I'm just trying to figure out kind of what the discussions have been between the operators and the neighbors and the city, and trying to figure out how we ensure that this will be as least impactful as possible as the two sites are developed.
You're absolutely right. And one of the requirements for going through an MOU process, an administrative process, is to have a neighborhood meeting that was held by Providence. It was attended by City of Brighton. And we didn't hear, frankly, a lot of concerns from those neighbors. There is the one home, frankly, that is within 2,000 feet of, that's within Brighton, at least, that's within 2,000 feet of this location, did sign a waiver and informed consent. So but the City of Brighton did not specifically reach out other than that neighborhood meeting.
Thank you. And thanks for sharing all this information today. It was really helpful.
Further questions from commissioners? Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Sura. Just so I'm clear, the condition of approvals that the City of Brighton is requesting is the electric drill rig. The second one, I just want to be clear, the condition of approval would be to require utilization of Tier 4 completions engines. And I ask that because if we tried to include the entire condition that is in the MOU, it includes the terms reasonably practicable, which you define in your MOU, but are not found anywhere in ECMC rules. And so are you comfortable with just the language of the requirement for Tier 4 engines or better during completions?
Yeah, thank you for the question. I think that if you read it, that reasonably practicable is in regards to electrifying those completions.
That's correct. Yeah.
Yeah, and I don't frankly believe that it is reasonably practicable right now to have hydraulic fracturing. We just don't have the amount of electricity needed out there to be able to do fracking and completions with electricity. So if there was all of a sudden a technology and battery powered or that became something that was available and commercially available, then we would say that it's practicable. But
right, that's captured in your MOU, right? So I guess my point is the city of Brighton comfortable not just adopting the language that's in your MOU, but utilizing the terms Tier 4 or better engines so that we don't have to get into this argument of us trying to enforce a definition of Brighton's that's not in our rules, which is reasonably practical.
That's fine. Again, the way that it's written is that is a minimum. It's a Tier 4 engine.
Okay. And then the third one, just so that I'm clear again, is just to simplify it, that we shall not apply the noise cumulative, the additional noise allowances for cumulative noise under our rules in this particular application. Is that right? I mean, your language in there is better, but that's the gist of it, correct?
That's correct. It's considered it's just going to be held to the 50 decibel standard at night and 55 decibel standard, a residential standard that is applicable to any location. It's not, the fact that there are two locations here doesn't trigger a cumulative impact analysis or cumulative impact rule under noise.
Okay. Thank you.
Thank you.
Further questions? All right, I'm not seeing further questions. If you want to stick around, Mr. Surrey, we may have some other questions for you later. Mr. Chicken, you're recognized for your presentation and or response to what you've heard so far. You've got your panel with you. Go for
it. Thank you very much, Director Robbins, or Chairman Robbins, sorry. Just briefly, I will say in my capacity representing Providence operating, doing business as POCO operating, and working with the city, where Providence supports Mr. Sura's statements. We support the inclusion of those conditions of approval as outlined today by Mr. Sura and has clarified through some of the questions. I'm sure all of the commissioners have seen the MOU. It's a lengthy, very comprehensive document, and most of those are coming right out of there. So whether we owe those obligations under the permit or under the approvals issued by the commission, or whether we owe them contractually to the city of Brighton, POCO is going to uphold those requirements. So I guess moving right into a brief introduction of the BL Vintage OGDP. We do have several witnesses on here. A handful of those witnesses are going to be putting on a presentation, beginning with Megan Grimes, POCO's Senior Manager of ESG, Max Goff, the Head of Assessments at Project Canary, Mark Smith, the President of Clean Connect, and Fred Witzel, the Chief Operating Officer of POCO, are all going to be involved in pieces and parts of that presentation. But we will also have our land engineering, geology, and Jason Frank, the project manager of Aquionics. All of those folks are online today as part of our panel, so that commission could get the best and most complete answers to any questions that they might have. I think first I'd like to, before getting into a brief introduction, I would like to note some updates to the director's recommendation. When that was issued, it only included changes to the application submitted through November 2nd. It's obviously November 13th. So certain things have happened in between that I think is important for the commission to consider. As Mr. Sura mentioned, the city and POCO signed a memorandum of understanding, and the city issued a permit for the BL Vintage OGDP and all of the areas covered by that to POCO. The city also had withdrawn its protest at the same time that the MOU was signed. And as noted, it's a very comprehensive document. And POCO and I believe the city would agree that it addresses all of the city's public comments. The MOU actually incorporates the public comments that were filed by Adams County as well. They had some very limited public comments they filed. Those were just incorporated right into the MOU exactly as Adams County had wanted. And a lot of it had to do with things like making sure that if there was an incident that POCO had to not only call the commission and the city, but they also had to call the county. So it was items like that, but that has all been incorporated in the MOU. One of the other items in the director's recommendation is the most recent version of POCO's alternative location analysis. It does have a typo in it. It references 40 wells. That was a throwback to the original application. It is 35 wells. We will be filing a correction of that typographical error, but it does not impact the effectiveness and the validity of the most recent alternative location analysis, which we will talk about in our presentation. There was also a question about what rule POCO was asking the commission to proceed on in terms of residential building units and the setbacks for that. I think it's clear from some of the questions the commissioners are already well aware. We are seeking Rule 604B4 substantial equivalence. That is because we have 3 residential building units within 2,000 feet. The nearest of those 3 residential building units has entered into and provided an informed consent to POCO. The other 2 residential building units have not, but that is despite lots of interaction over the past 12 plus months with all 3 of these owners in these residential building units. And we will have more information and can discuss any commissioner questions regarding those other 2 informed consents. But I guess the short version is we talked to them a very lot, and they kind of didn't want to do anything. They didn't want to be involved. They didn't want to protest. They didn't want to sign. They just didn't want to be involved in the process. And so we do believe, though, that the technological advancements and the kind of in excess of what's required by both city and ECMC rules in a lot of areas on this Brighton Lakes 2017 pad meets that substantial equivalence requirement. And what we're happy to provide testimony on that. And part of that is why Mr. Goff and Mr. Smith are here, because we are, the pad is a Project Canary certified platinum location, and he'll explain what that means and what that means to, in terms of contact with the RBUs. I think it's also important to note that the Brighton Lakes 2017 pad has been in existence and has had 8 wells producing on it since late 2019 or early 2020. And I'm sorry, my lighting here is deciding to turn off. I hope everyone can still see me. And so this is a request to expand that pad, not to create additional disturbance by putting in new pads and things like that. And then, moving from that into just a general discussion of what is being requested here today. We are requesting the approval of the BL Vintage Oil and Gas Development Plan. That would be about 2,094 acre OGDP area. It would encompass not only the existing 640 acre, what we call the Brighton Lakes drilling and spacing unit. That is the one that has the 8 existing wells in it. It would encompass that. And as far as that spacing unit goes, we are requesting the addition of 3 infill wells to the amendment of that order. So that order is 407-1879, and we're seeking to amend that to add 3 infill wells and to decrease some setbacks. Our request also includes a spacing request to create the 640 acre Buckley DSU to the immediate west of the Brighton Lakes DSU. It's just a mirror unit. Also, that would be for 12 wells. And then also creating the 800 acre Bar Lake DSU, which is that one on the map you can see that extends out to further to the east. That would be an 800 acre DSU, and that one would also be for 12 wells. POCO has spent a lot of time working with the city, working with local government, and doing its best really to figure out a way to develop these lands without creating a lot more impact and without creating a lot more problems, and does believe that its application today for the OGDP and for the spacing changes will protect public health, safety, and welfare, the environment, and plants and wildlife as well. But with that, and not to belabor the point, I would turn this over to our first witness, Megan Grimes, who is going to kind of helm the presentation. She'll have a couple of slides in there where she'll ask others to jump in. And of course, if there's questions along the way or afterwards, we're happy to not only answer them, but make sure that we've got the best people to answer those questions as fully and completely as possible.
Thank you, Brent. I believe Andrea is going to share the presentation. Here we go. Perfect. Okay, go ahead and advance the slide, please. I won't belabor the introduction of presenters. Brent did a great job of that, so we'll go ahead and move on to the next. In our presentation today, just a general overview of what we're going to talk about, general information on the application, the existing pad, and what we're requesting for the expansion. We'll discuss the relevant local government disposition, as well as our community outreach efforts, the development timeline of this proposal, cumulative impacts and best management practices, and then want to highlight our facility design that's in existence, as well as the planned facility design, and then we'll summarize and make a request for approval. Next slide, please. Next slide. Providence Energy LLC DBA POCO Operating LLC is an ECMC operator, and number 10694, and is wholly owned by Providence Energy Ltd. We are headquartered in Dallas, Texas, but we do maintain an office in Colorado, down in Englewood, and that is where our operations team works. POCO maintains all financial assurance, insurance, and operator clearance with ECMC, and POCO will be the operator of the BL Vintage Pad, the only oil and gas location proposed in this OGDP. Next slide, please. The Brighton Lakes pad is an existing location with 8 producing wells on it. The expansion we're requesting for the BL Vintage application only requires approximately 2 additional acres to accommodate the requested 27 additional wells in 2 additional spacing units. Our relevant local government, as you know, is City of Brighton, with proximal local government being Adams County. And there are 3 RVUs within 2,000 feet of the working pad surface, the closest being 711 feet to the east.
I'm sorry, Ms. Grimes. Sorry to interrupt you. I just received a text from Chairman Robbins that his internet went down, and so he's been disconnected from the meeting. So wanted to ask you to just pause while he reconnects.
Sure, happy to.
Thank you.
Okay, I'm back. Sorry about that.
Are we ready to go then? Okay, very good. Okay, just I'll finish up the general facts here on the application. We are requesting an additional 27 new wells that would go into 2 new spacing units. Those are called the Buckley and Bar Lake units. This application does not fall within a high priority habitat area or floodplain. It does fall within a DIC. We'll discuss that a little bit later in the presentation. Next slide, please. Just a general procedural background of the application. We did start this OGDP in February of 2022 with our pre-application notice. You can see we did file the original application in April of 2022 and an amended application in December of last year. That was due to ongoing negotiation with an offset operator in a competing application. We did receive completeness in March of this year and then spent the subsequent months between then and now negotiating with City of Brighton to come to an agreeable MOU, which was executed, as you know, at the end of October, which brings us up to our hearing date today. Next slide. Next slide, please. Just a little bit on the local government disposition. We attended a pre-application meeting with City of Brighton in March of 2022. The neighborhood meeting that Mr. Sura discussed was in May of 2022. And then we submitted our permits to the city in April, April this year. That was in coordination with the city to have our OGDP make it through the completeness process before filing with the city, just for consistency of documentation at that time. Our MOU was fully executed end of October, and then our permit with the city was approved on November 2nd. Next slide, please. Next slide. Again, as Mr. Sir mentioned, POCO did host an open house style neighborhood meeting on May 19th of 2022. That was at the Bison Ridge Recreation Center in Commerce City, just offset to where this location exists now. POCO and City of Brighton had representation in attendance. We did have 2 households attend in person. Neither of those were the RVUs that we've discussed already. The City of Brighton did have their planning director, Mike Tilka, present, as well as Mr. Sura. All of the parcel owners within a half mile were invited half mile of the location were invited to attend the meeting. And then some of the discussions at the meeting included water use, royalty payments, air quality, timeline of operations, and noise impacts. Next slide, please. This is a map, our cultural features map, and you can see the 3 RVUs that have been discussed, 2 to the east, 1 to the southwest. We did have extensive conversations over the last year or so, more than that, with all 3 RVU owners. We were able to reach an agreement with RVU number 3, which is the closest to the east, and we did get an informed consent signed with them at the end of September. It is worth noting also these are the same owners that were living in these RVUs during the initial operation of this pad. Next slide, please. Just want to discuss briefly our community outreach plan. This pad is within a census block identified DIC for having a minority population of 55%. It does not identify this census block as having linguistic isolation. POCO will continue to engage proactively with the owners and tenants of the RVUs within 2,000 feet, updates to include updates on the development timeline if there's any adjustments, and always happy to answer questions and have an open relationship with those owners. During the first occupation of the Brighton Lakes pad, POCO did not receive any complaints, formal or informal, by ECMC or City of Brighton. And then worth noting, there was 1 complaint filed with CDPHE regarding odor. And we were able to use the existing canary data to provide, to evaluate that complaint, the date and time that it occurred, and provide feedback to CDPHE to show that there were no spikes in emissions or, wind direction pointing in the direction of where the complaint came from. And then lastly, we did participate in CDPHE consultation in March of this year. Next slide, please. Next slide. A little bit about our, excuse me, our alternate location analysis. It is worth noting again, this is an existing pad, and the expansion we're requesting will request only minimal surface disturbance, approximately 2 acres, to accommodate 27 additional wells. We did evaluate 5 alternate locations. You can see those on the map, 4 to the south, 1 to the north. And it became evident that to access the same spacing units, it was likely that we would have to develop 2 additional locations to reach those same units. And so it really became evident that the existing pad with minimal expansion was the best option here. The current location is sited approximately 4161 feet away from nearest high priority habitat. And when POCOS evaluates locations, we do evaluate wildlife as a standard practice, and as such, engaged a wildlife biologist to do a consultation, even though it was not necessary. Lastly, I would point out that POCO has a good working relationship with the surface owner of this pad. Next slide, please. Next slide. I want to talk a little bit about the development timeline that we're proposing. I know that the goal is to execute as efficiently as possible. However, due to POCO's commitment to electrification of the drilling rig, there are limitations based on grid power availability. And POCO has engaged United Power already to discuss what those blocks of availability would be for operating a drilling rig. And so our timeline that you see on the screen here is consistent with those blocks of availability of grid power. So our plan and desire is to start construction in Q2 of 2024, and then continue developing based on availability of grid power for electrification of the rig. Next slide, please. Next slide. I'm not going to read these. I just want to point out the list of BMPs that POCO has committed to, and there are some that we want to highlight in the next slides. But I would point out the original noise BMP called for installation of a 32-foot temporary sound wall, and through the MOU with City of Brighton, we've committed to a 40-foot sound wall, as well as permanent installation of 10-foot sound walls to more effectively mitigate the noise issue that was discussed by Mr. Sura. Next slide, please. POCO has participated for the last couple of years in Project Canary's Trust Wall certification process. It's a holistic environmental assessment of the pads that we operate. And I'll let Project Canary speak to all of those factors and how that calculation is reached and the certification is issued, but would point out that this Brighton Lakes pad received a platinum certification from Trustwell, which puts POCO in the top 10% of operators for emission standards in the country. This certification also provided POCO with the opportunity to sell certified gas to the local utility provider. That's an ongoing effort, but one that we wouldn't have without this certification. Next slide, please. I'd like to turn over the presentation to Max Goff with Project Canary. Max, if you're ready.
Thank you, Megan, and thank you for everyone on the commission for being here today. Once again, I'm Max Goff, Head of Environmental Assessments here at Project Canary. First, want to go over some of our professional relationship with POCO. To the best of my knowledge, Project Canary has been engaged with POCO operating for the better part of at least 2 years. And Megan is correct that we have gone through our Trustwell environmental assessment, where we take a holistic view and approach towards assessing oil and gas operations from inception to asset retirement. In essence, the assessment that we are doing is looking at local factors inherent to where the operator is conducting their operations and are comparing those to control measures that the operator is doing to mitigate those risks inherent to the operation. I want to go off and say that POCO has earned a platinum rating, which represents the top 10% of operators. There is no higher delineation than that within our rating system. Things that are of critical importance, in my professional opinion, is that POCO has demonstrated a methane intensity of 0.03%. I'm not expecting you all to be aware of what that signifies, other than to say that their methane intensity from a air pollution perspective is frankly world class. In addition to the assessment work that we have done with POCO, this is an ongoing relationship where we're able to take our decades of environmental and operational experiment and provide opportunities for continual improvement for their operation. I've seen firsthand the continual engagement and proactive nature of everyone on the POCO team to frankly be one of the best operators in Colorado, also in my professional opinion, within the United States. Part of the environmental assessment is looking at air attributes, water attributes, land attributes, and community attributes, in which all manners POCO has excelled at. This process includes a thorough and extensive documentation review of everything that goes into these types of permits and packages, as well as their ongoing best management practices. And then from there, we're going into subject matter expert interviews, essentially the professionals with the POCO operations teams, to see how they're really conducting their operations. Follow it up with that is a site visit and inspection where we are really just covering everything that was stated what was done, how it was planned to be done, and how it was actually accomplished. Megan, is there anything else that I can provide here?
That's great. Thank you, Max.
I would also like to bring up one more thing. The commission, that in addition to Reg 7 TVOC air quality monitoring that is required, POCO has installed permanent fixed methane sensors as a means of proactive leak detection and repair, where the POCO team is able to get real-time information on any potential upsets that may result in an unintended release of methane, where they're able to act on it within a matter of minutes.
Thanks, Max.
Thank you.
Next slide, please. This next slide actually discusses what Max was alluding to from the installation of LDAR equipment. POCO is committed to using technology to reduce emissions, not only in our facility design, but in technology like Clean Connect AI. And again, we have someone with Clean Connect here to discuss the technology, how it works, and what it allows POCO to do that's beyond requirements. And so I won't belabor this slide. We'll turn this over to Mark Smith with Clean Connect.
Hey everybody, Mark Smith, Clean Connect. So what we provide is real-time monitoring using a series of cameras, a OGI camera, optical camera, and others. So we do real-time VOC gas detection and quantification, non-invasive tank monitoring, PPE detection, compressor monitoring, and so on and so forth. You can see that our cameras are mounted up there on the top, and they look over an entire site. Okay, and they're doing a complete tour of the site every single hour. You can go to the next slide. So Colorado CDPHE has an ALT-AIM program, or the Alternative Approved Instrument Monitoring Method, which we are approved for. And so to get that, we had to do these 6 things. So show that we could do source level detection, so you can see it at the source, blind testing, to be able to do, and we are certified to go out at 100 meters, 2 kilograms per hour, LDAR equivalency. So we had to prove that our AI autonomous LDAR system was equivalent to somebody doing monthly OGI LDAR inspection. We also submitted an alternative work practice, which all the operators, if they use Clean Connect, are required to adhere to. Operator endorsement, so along with our application, PDC and Civitas, for example, included their letters of endorsement, and then EPA Region 8 approval was included in all that to get our alt-aim with CDPHE. Next slide. So these are examples of the blind testing results. We were able to do different blind testing things done on a production facility. You can see it's out there to 120 meters with a 98% true positive rate. Next slide. So we have this approval letter that each of the operators that use Clean Connect in Colorado get to use. What it basically says is, if you use Clean Connect, it replaces regulatory monthly LDAR, regulatory AVO inspections, regulatory tank emission monitoring, basically eliminating 92% of the regulatory scheduled callouts, which is great because that's a lot less trucks on the road because it's continuously going on site. Next slide. So this is our alt-aim approved workflow. So we have AI detection, allows the operators to then have AI assisted diagnostics. So they literally see the source of the leak with a video, okay? Which then allows them to issue any kind of repair that may need to be done. We have a built-in workflow. When they say, yes, it's been repaired, the AI on the next tour stop can verify that that repair is done. All that is reported, source level emissions inventory reporting, and we use that data to retrain the model so it continually gets better. Next slide. Okay, that's it.
Thank you, Mark. Okay, just a couple more slides here. We do want to talk a little bit about our facility design because we think it's unique and largely responsible for our ability to limit emissions to the extent that you've heard already today. So next slide, please, Andrea. And I would turn it over to Fred Witzel to discuss the design of our facility.
Thank you, Megan, and thank you, commissioners, for hosting us today. We're pretty proud of this particular facility. We employ what has some in the industry call a tankless design, but in fact, we do have a minimum number of tanks for any sort of upset conditions and also to handle any produced water. The design of our facilities, if you've seen pictures on some of the slides that Megan has presented, we have a bulk and test setup instead of individual separators for each of the wells. That was sort of a standard practice by many in the industry. We have employed this design on all our pads and any new pads that we develop in this area, and the BL Vintage pad will be no exception. It limits pressure vessels, it limits connections, it limits potential emission sources, and this is just a simple flow diagram. One clarification is the Brighton Lakes pad at this point is fully electrified. We have no gas generation on this facility, no generation at all, let alone gas fired generation. All pneumatic controls are instrument air, and we already have a power drop from United Power here. So when if we are approved and we include the drilling operations with electric rig, that power is there. We are negotiating with United Power because it's quite a bit more draw, so we have to make sure that we have the equipment on location to accommodate drilling operations at that time. So this is the facility. We've asked Project Canary do 24-hour monitoring and also Clean Connect. It's great technology. It works really well. You can heat it. You can see a heat signature of a truck engine when it pulls on location, and so it's great for monitoring. And also, we look at it as a proactive approach. As Megan mentioned, we had one complaint during drilling operations. We were able to produce the information to the CDHP and showed that we didn't have any emissions. So it just wasn't our facility at that particular time. So happy to answer any questions about this design.
Thanks, Fred. I think we'll move on and take questions at the end, I believe. Okay, so we'll just finish up here with summary and request for approval. BL Vintage Oil and Gas location is protective of the public health, safety, welfare, environment, and wildlife resources. Our application is supported by Director Murphy's November 2nd recommendation for conditional approval. And BL Vintage includes best management practices to avoid, minimize, and mitigate temporary impacts to surrounding environment. And POCO Operating would respectfully request approval from the commission of this BL Vintage OGDP application. Thank you for your time, commissioners, and happy to take questions.
Great. If you want to drop the screen share, that'll give us a little more ability to see everybody. Great. Just looking at my notes. This is the first time we've had an application that has presented not only with the trust well, but also the Clean Connect. Is there anything further you want the commission to understand with regard to those approaches? I assume, Mr. Chicken, that is the area that you would indicate establishes substantial equivalence protections. Is that accurate?
That is correct. That is correct, Chairman Robbins. That, you know, when you look at the history of this location, the fact that the 3 RBUs only became RBUs because of the 181 changes, and the fact that POCO has committed to, I mean, just real-time monitoring across the board through Clean Connect and being certified by Project Canary, as well as, I mean, and we can go through other items if the commission so decides, but there's, you know, there are other items that that POCO has agreed to and obligated itself to do in the MOU as well, that does establish the substantial equivalency. There's just a lot of emissions items and things like that that are handled differently at this pad than I think maybe the commission's used to seeing. And I think it's those items that, you know, if the commissioners have questions and they want to understand more, that's why we have Mr. Smith and Mr. Goff here, so that if commissioners want to dig in a little bit deeper into those items and understand those a little bit better. And I think it's probably a good time to also note that, you know, we have also agreed in the MOUs where we couldn't agree to something, where POCO couldn't agree to something because it didn't actually exist yet. You know, we've done what we can to say, I guess the what I've used with Mr. Sura is if they build it, we will come. So, you know, for example, the produced water pipeline, when you look at what POCO has agreed to in the MOU in terms of truck traffic and timing, you know, the mats to keep the mud off of the roads in the first place, the maintenance of the roads to make sure that they stay clean and that we're not creating other problems for other users of the road and the roads and those type of things. You know, arguably it's a more economical for POCO to use a water pipeline, but there isn't in fact a permitted water pipeline there yet. We from Mr. Sura's efforts, and thank you to him again for this, he's been able to get the future operators of that pipeline on board with the concept of taking third-party water, such as POCO's water, and that type of stuff. And so, you know, the bottom line is, if we are able to, POCO as a whole, any of the things dealing with noise, you know, fugitive dust, emissions, water handling, piping, piping product away and those type of items. We've done everything we can to say, either yes, we're going to do that because that's better for public health, safety, welfare, and the environment, or we're going to do as best as we can until something better comes along. And when that something better comes along, we'll do that too.
So let me, a couple of follow-ups. The blocks of available electricity and sort of that time frame, that's normally I think we encourage operators to kind of get in and get out. And obviously this is a different approach. It does allow you to use the electricity when it's available. I just found it interesting. And so there's 2 or 3 different occupations. Each one of those is associated with the time that the electric company indicates they'll be able to provide sufficient electricity. Is that accurate?
Yes, that is correct. And as noted, the pad is fully electrified. We're going to use electricity for everything that we possibly can out there. In fact, I think the only on-site compressors that aren't electric compressors are compressors that we have on standby for safety purposes, right? And that is because United Power, and I'm sure we've got other folks on as witnesses here that may be able to answer this even better than I could. But the idea is that, United Power is telling us, we're telling them the power we need to do the operation. And they're essentially telling us when they're going to have that power available to give to operations, and not be diverting that power to some other, higher and more important use at a high use time, sending that power to a hospital or something like that, when there's high demand. But I'm sure there's other folks on here that from POCO that have interacted directly with United Power and can probably add a little bit to that. But you are absolutely correct that our development schedule is driven in large part by the fact that when you electrify everything and you have that power coming from a third party instead of being generated by burning fossil fuel engines on site, you're a little bit at the mercy of the company that's providing the power.
Okay, one, I think, final question. This relates to the 2 RBUs within 2,000 feet that did not provide informed consent. You indicated in your application and your PowerPoint that there was, a lot of reach out. I didn't get a sense of what's their perspective. Obviously they were there when the first wells were drilled. Are they just sort of stay out of our way? We are independent people. Are they frustrated with the development? I mean, can you give me some additional perspective of the other 2 that did not provide informed consent?
So, Chairman Robbins, I think I'll turn you first to Megan Grimes, who can provide some of that information. And Ms. Boyes may also have some background on that because they had the boots on the ground interaction with these individuals.
Thank you for the question, Chair Robbins. I would turn it over to Allison. She was extensively involved in the efforts to work with the RBUs, communicate with RBUs, and try to see agreement on those informed consents. Allison?
Thank you, Megan. Good afternoon, commissioners. So we're talking about the 2 parties that did not sign the informed consent. Communication started with these 2 parties back in May of 2020. So they've spanned 18 months. As it's already been stated, they were the homeowners at the time the original 8 wells were drilled. I began consulting with Providence in July and began conversations with both these parties in August regarding this application. Both parties have gotten the overview. We've walked through all the plans with the City of Brighton and CDPHE, maps, etc. Neither party wishes to protest this application. They just kind of are washing their hands of the situation and are aware that development has occurred and will continue to occur. Do you guys have any, commissioners have any further questions?
I don't at this time. I'm going to look to my fellow commissioners for questions to the panel. Commissioner Cross?
Thank you, Mr. Chair. And I want to just build on a little bit of what you asked about in both those questions there. And kind of going back to the multiple occupations that you asked about. Is the multiple occupation something that was kind of discussed in detail during that town hall or open house, as you called it, as well as with these RVU owners? So not just that there was development occurring, but it was going to kind of continue to come in phases?
I'll take.
Go ahead, Alex.
Go ahead, Megan.
I'm happy to take the front end of that on the open house because Allison wasn't consulting with us at that time. We did discuss a phased approach to the development of this application. However, the actual dates are probably different than what was discussed originally just because of the time it's taken to get to this point. So there's been a shift in actual start dates. From what we talked about at the open house neighborhood meeting. However, the phased approach was discussed at that point. And I would add that it's not only, electrification is the primary driver here, but it's also from the perspective of the order in which these wells will have to be drilled to accommodate the directional complexities of reaching into 3 units from the same location, setting down the deepest first and working our way up. So the timing as well as the complexity of the directional is really driving the desire to do this in a phased approach.
And you said it was discussed, even though the dates may have changed a little bit. Was there any specific feedback from the RVU owners, from Brighton, from those that attended, especially the town hall open house, I think is what you called it, with respect to, concerns about coming in multiple times, or does the electrification sort of offset the concerns that they have?
Electrification is of the rig anyhow, is a more recent discussion. With City of Brighton, it was not necessarily a topic of discussion beyond the electrification of the existing pad at the open house neighborhood meeting. There were no specific objections or requests for some other development timeline from those who participated in line or in person or online at that meeting.
Okay, that is helpful. And then the other thing I wanted to ask about, and I did have some questions ahead of time, but one of the things I asked about was kind of the use of the infills here and why they weren't developed the first time around when some of these were drilled. And with respect to one of the wells, it mentioned that the targeting of the Niobrara A was an exploratory only target. And so now you're wishing to test that. Depending on that test, are you having plans on potentially coming back again to develop more into the Niobrara A, or is this kind of seeing how it goes, but this is kind of the last of this pad?
So, Commissioner, I can refer you to Mr. Witzel, who's giving some of the facility design. He's very knowledgeable and can answer that question better than my very short attempt via email prior to the weekend.
I know Brent provided a response to that. The Niobrara A is a technically challenging reservoir. We did drill a successful well, and it's on par with our expectations. So our request for an additional Niobrara A is just to infill that particular pattern. We do not anticipate coming back to the commission. Fortunately, technology, completion procedures have done so that we can effectively drain economic resources with less wells. So just one additional well to that particular unit at this particular point.
So you already have tried that out, and you're just continuing with it. It's not completely exploratory. Okay.
No, it's not. We had tried it on the first well, and it worked quite well.
Okay. Thank you. That's the only questions I have right now.
Further questions, Commissioner Messner?
Thank you, Mr. Chair. Just a couple of questions. I do want to just note that I appreciate the evolution of this application over the years, and a lot of the considerations that are being given here. And my understanding Mr. Chicken, is that your argument for meeting the standard of substantial equivalence is the application of the BMPs associated with the City of Brighton MOU, as well as considerations of incorporating the BMPs proposed by Adams County. So my question is, understanding that, you know, the burden needs to be met for ECMC, are there BMPs that you're proposing in the MOUs that are not incorporated in the Form 2A by ECMC? So understanding that you're utilizing those BMPs as your burden to meet substantial equivalence. I'm not sure all of those BMPs are actually in the Form 2A. I think it seems like a lot of them are, but I just want to hear from you whether you feel like all of the information or the BMPs that you're proposing to meet that standard are incorporated into the Form 2A for ECMC.
I believe, Commissioner Messner, not only is that the case, but I believe the MOU is part of the Form 2A. As a, you know, as a general matter, that it, you know, if the whole point of the time spent working closely with Mr. Sura and the folks in the city was to place the MOU and the Form 2A and the conditions of approval of the OGDP on equal footing, so such that POCO would have those obligations under, you know, all three of those areas, and that there wouldn't be any way to play fast and loose and say, well, wait a minute, that wasn't a permit condition, that was in the MOU. The idea is that they're all equivalent, and we're, you know, and POCO is held to that high standard across the board.
Okay. My understanding is just, and I would like to get an opinion from AG Mercer, who's appeared, but is that ECMC would not be able to enforce an MOU that was developed between the City of Brighton and you, the operator. Only the BMPs that are associated with the Form 2As that are specifically called out or conditions approval that this body may impose upon an application prior to approval. And so I guess AG Mercer, do you feel like that's captured in order for them to be able to meet their burden as they've indicated?
Thank you, Commissioner Messner. So I would agree with the way you characterized it. The MOU is not part of the 2A. It was not submitted to staff as part of the application and has not been made a part of the ECMC permit. The provisions that ECMC can enforce are those that are listed on the actual Form 2A and attached plans themselves. So the BMPs on our permit. As a general matter, it has been the practice of ECMC in the past to not sort of adopt MOUs or similar agreements with local governments as part of our permits, because there are issues with whether ECMC would have jurisdiction to enforce all of the various commitments, whether it's appropriate for ECMC staff to interject itself into agreements between the operator and the local government, et cetera. So right now, the Form 2A stands on its own, and the MOU is not a part of it. I will say, though, as a caveat, that the commission, in my view, can certainly consider the MOU and the commitments that the operator has made there when assessing this substantial equivalence. Because one of the prongs under 604B4 is that the commission should consider the disposition of the local government, which here includes that MOU. And as Mr. Chicken and Mr. Sura have explained, that MOU is fully enforceable by the local government. It just is not enforceable directly by ECMC. Does that answer your question?
Yeah, that certainly helps answer the question. I think the root of the question, though, is to the applicant that to ensure that any BMP that's being proposed to meet the burden of substantial equivalences is included in the 2A. So my question is, are we missing anything that's not in the MOU that you feel like needs to be in the 2A in order for you to make your case that substantial equivalency has been met?
I don't believe that's the case, but I would encourage the commission and you know, we've been updating this thing and you know, bringing stuff over right up to kind of the wire here, and I believe that almost all of the BMPs that are represented by the MOU do appear in the 2A, but to the extent that POCO is obligated under that MOU to perform a BMP that is not in the 2A, we are happy to you know, add that to the 2A so that it is adopted as part of the 2A. Because the bottom line is we have 40 pages of BMPs, single space, that we've agreed to, and so POCO is not going to agree to those in an MOU and then say, oh, we don't want those in the 2A. Anything there that you know, isn't carried over, we are in favor of carrying that over and making that express in the 2A. And I think as AG Mercer noted, you can still consider for purposes of today whatever is in that MOU, and if there are additional conditions of approval that the commission sees in the MOU that it did not see in the 2A, we would be in 100% favor of just adding those in, because we're already on the hook for them, so why not? You see, and I'm sure Mr. Sura would feel comfortable making that agreement as well, because as he noted earlier on, the city is concerned about its ability to enforce. And so he's only specifically requested a handful of BMPs that I assume he doesn't see in the 2A. But I would assume Mr. Searle would be on board with that as well. And he's still here, so he can comment. But
okay, that's fine. I just was making sure that you had a chance to look at it, and I understand intent, and I think you've made your intent clear. And I think the record's clear on that. So I appreciate that. I did want to just ask about one other item, is understanding, at least in the hearing today, that there's a good probability that there's going to be produced water takeaway available. And currently in our Form 2A, the commitment that POCO has made is to truck produced water away.
correct.
I wonder if the applicant would be comfortable with the BMP, which I think you've already indicated that, you know, should produced water takeaway become available, that they shall connect to and utilize that opportunity, and then remove any unnecessary tanks that associated with produced water once that occurs.
Certainly, and I mean it's real, Commissioner Messner. It's very simple. POCO does not have the ability to all by itself do this, to do this produced water pipeline.
Yeah, and that's why it's in there. It would say that should it become available, right? And I understand that.
And that's exactly it. If they build it, if they'll take our water, and if they're not going to charge us, you know, 10 times the going rate for our water, then we are all about putting our water in that pipeline.
Okay. Well, thank you. I appreciate that. And that is all the questions I have.
Mr. Sir, if you could visualize yourself, I think you're still with us. Yeah, just wanted to give you an opportunity to speak to this line of inquiry. In a former life, I did a lot of MOUs and operator agreements, and I know there was always a bit of a fine line. What goes into the MOU? What goes into the commission? I know that some of our staff is likely, you know, would not want to see all of the MOU stuff in the you know, in approval, because some of it's local, right? Do you feel like you've divined that line correctly? And except for the 3 additional asks you made this morning, that from the Brighton's perspective, you're comfortable?
Yeah, thank you for the question. I visualized because something that AG Mercer mentioned is that, you know, something that we took into account when we put forward our only 3 requests for conditions of approval. I recognize that MOUs can't be, you know, that weren't worked through with ECMC staff. They weren't involved in those. They don't have enforcement capability on things like transportation and landscaping. And that was something that you know, we're not asking for. We took the 3 issues that I feel most strongly about that really do need to be as conditions of approval for the city of Brighton to feel comfortable with this approval from ECMC. You know, we just don't have the staff to be able to be out there to enforce, whether it's electric drill rigs or tier 4 engines being used, noise requirements. Really hoping that this would be something that you would agree belongs as a condition of approval and will therefore be able to be enforced by your staff.
Thank you for that. Appreciate that additional clarification. Other questions for the panel or for Mr. Sura or for staff from commissioners? All right, seeing no further questions, does anyone desire to initiate deliberations? Commissioner Messner.
Thank you, Mr. Chair. So like I had indicated before, I think I appreciate how this application has evolved. I appreciate the involvement of the proximate and relevant local governments. I appreciate that there's been an attempt to come to agreement for a memorandum of understanding and update existing memorandums of understanding. I think there's been a lot of evolution of this application, and I think the evolution has been a good thing. I think the incorporation or the proposition that was provided by the applicant on how they intend to meet substantial equivalency has been met both with the incorporation of the BMPs that are associated with Form 2A, with some additions as recommended by the city of Brighton and myself, as well as the understanding that the other elements of the memorandum of understanding also can be considered as evidence in developing substantial equivalency. And I think those things all do accomplish that. I think it's important to understand that that the timing of operations and the coordination of operations between this applicant and you know, other operations that are adjacent to it end up being critical to you know, avoiding, minimizing, and mitigate potential adverse impacts to a disproportionately impacted community and residents inside of 2,000 feet. And those impacts of pretty substantial operations you know, potentially are significant, and I appreciate that the efforts that have been made to you know, help minimize and mitigate those, but the timing in this commissioner's standpoint is going to be essential. And you know, I think that timing is captured pretty well in not utilizing the potential increases in cumulative noise standards, because I don't think it's feasible to be able to operate pre-production activities for 2 different operations concurrently and still be able to meet those standards. And so understanding that, I'm going to be in support of this. I think that the commitment to connect to produce water takeaway is an important one for me, and I appreciate that the operator is willing to do that if it becomes available. And I understand that if it's not available, it's not available. I understand the challenges around that, but that if it does become available, I think that ends up being a big one as well. So, so that's my thoughts.
Thank you for leading off. Others with thoughts? Anyone want to make a motion?
Mr. Chair, I'll try to make a motion, but it's still a little vague to me whether the conditions of approval that are associated with the comments by the city of Brighton need to be incorporated in the motion or not, or whether those have been kind of automatically incorporated as part of this conversation.
Hey, AG Mercer?
Thank you. So the Form 2A already includes BMPs committing that the operator, 1, will use Tier 4 engines or better for hydraulic fracturing, and 2, will use electric drilling rigs. So it is my understanding that those are unnecessary to add as sort of duplicate COAs. The cumulative noise BMP that Brighton has requested and the operator agreed to would need to be added. And if you would like to, I wasn't sure, Commissioner Messner, if you were desiring to add something about produced water takeaway as a BMP or just sort of note the commitment for the record.
I would put it in as a BMP, but I also want to ask about the BMPs that were suggested by Adams County. And I understand because the applicant said it at a hearing here that they're committing to that, but it was not clear to me that those were included in the 2A.
I don't believe that. So those, just to make sure we're on the same page, there was one about regular cleaning of the tracking pad and street sweeping, and another one about including the Adams County LGD in the event of a spill. Were those the two that you are referring to?
That's my understanding, correct?
Okay, based on my review, neither of those appear on the 2A, so they would need to be added if that's your desire.
And we're fine with that. They're straight out of that MOU. So POCO's okay to add both of those.
Okay. I'll let Commissioner McGowan make a comment before I try to make a motion.
Great. I'm glad that you caught me before you made your motion. And I wanted some clarification on whether or not the pad is going to have electrified equipment. And if so, is that also already in the Form 2A? Sorry, we had a lot of OGDPs this week. And if not, I would like that added too, if that's what if my understanding is that's what the operator has also agreed to.
There is a BMP on the 2A. It's at the bottom of page 16 that says operator will use electric equipment and devices, e.g. vapor recovery units, fans, etc., to minimize combustion sources on the site. Operator commits to VRU, compressors, SCADA, and LACT. So if that covers what you're talking about, then yes, it's already on the 2A.
Okay, I make a motion to approve I'm just pulling up the docket number, one moment.
2204-00084.
That's correct. With the conditions of approval that the cumulative noise, the additional allowance for cumulative noise standard be not applied to this application, that the applicant connect to produced water takeaway if and when it becomes available, that the applicant devise a plan for regular cleaning of the tracking pad and street sweeping to clean up and prevent debris from leaving the facility as a necessary stormwater pollution prevention measure, and that POCO notify Adams County local government designee in the event of any reportable spill or release pursuant to COGCC Rule 912, at the same time that they notify ECMC and the relevant local government.
We have a motion.
Second.
We have a motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Chicken, and to your witnesses and to staff for the good work on this application.
Thank you, everyone. Really appreciate everyone's efforts. Thank you.
Commissioners, we still have 2 to go. It's 12:44. I would suggest maybe a 30-minute break. Does that sound about right? Come back at 1:15. Very good. Ms. Amaro, if you could post that we'll return at 1:15.